because we all need
not. And so we're really excited to have Roger Royse here today. He's the founder of Royse Law Firm, and you are going to be going over some common mistakes that you've seen startups make. I'm sure people have questions for you as well. So when we get started, we're really excited to have you.
All right, give me a second. Give me a second. Let me find my PowerPoints. Oh, this is touchy.
It's always difficult to do on big screens.
Huh, oh, here they are, way down at the bottom. All right. Okay. All right, thanks very much. Sorry for the delay, everybody. But thanks for being here. My name's Roger Royse. I'm the founder of the Royse Law Firm. We're a business, whoops, how did that come up? Corporate and tax firm in Menlo Park. We have offices in San Francisco and Los Angeles. And I'm going to talk to you today about some common legal issues that I see with startup companies. How many people here are startup entrepreneurs? Pretty much everybody. Any investors here? Okay. Service providers like me? Okay. Couple. Okay. Sorry to do this. I got to cross over. So again, my name's Roger Royse. We're the Royse Law Firm. We're about 30 lawyers. We represent technology startups. And this slide set is actually based on a book that I have out. It's called Dead on Arrival: How to Avoid the Legal Mistakes That Could Kill Your Startup. And if anybody would like a digital copy of that, just leave me a card. I'm happy to share that with you. I'll go ahead and email you a copy. So the impetus for this is that during my career, I have noticed that companies would make the same mistakes over and over again. And I started out practicing in the Midwest. After that, out in oil patch. After that, I moved to New York. I actually worked on Wall Street with a big law firm, worked with international, very large companies, investment bankers, etc. I did some deals down in Hollywood, and I eventually ended up here in Silicon Valley doing technology companies. And you know what's really interesting about this is that in all of those different geographies and all of those different markets and all those different industries, same mistakes. You know, everybody seems to, mess up the same stuff. And that's why I'm here today, because this is just universal. And these are the things that you don't want to have happen to you. And as startup entrepreneurs, you know how difficult it is to get across that finish line, to have a successful company. You know what all the hurdles are, right? You got to get the team right. You got to get the product right. You got to get into the market at the right time. You got to hope you're not in the middle of a recession. All of this stuff has to come together. You got to get investors that'll work with you. It's really hard to get that perfect storm of success. I can tell you story after story about companies that I've seen that just hit the timing wrong, but had a brilliant idea. I mean, I saw a lot of Facebooks before there was a Facebook. Their timing was just wrong. And I could go on and on. Gig economy businesses. So if you get all of that accomplished, if you've managed to do all of that, the last thing in the world you want is for your company to fall apart because of some silly legal mistake that could have easily been avoided. And that's why I'm here today, to make sure that doesn't happen to you. Now, you're doing the right thing by being here, because this is the kind of thing that you really have to educate yourself about. You cannot rely on your lawyer to just volunteer all this information to you. Right? You really need to know what questions to ask, what to look out for, what to prioritize, what's important to you. So self-education, or education, is really the most important part of this. Okay, I promise I won't walk in front of that screen again. So let's go through my list here. And these are in no particular order. But let's start with one of the, what I call, dead on arrival issues. And this is the first question that I ask to startup entrepreneurs when they walk into my office and they sit down. This is the very fundamental first thing. We have to get past this. Like, do you own this idea? Do you own this intellectual property? Do you own this company? All right? And what I'm worried about is that there might be an employer someplace that would claim some rights to it. Because a lot of people do this part-time, at nights, and on weekends. So here's the 3 things you need to know about this, all right? The 3 things is that whatever it is, your business that you've developed, your startup company, if you are currently employed by somebody else, number 1, it's got to be on your time, not company time, okay? Nights and weekends are okay, provided you're not working at the company at nights and weekends. That brings me to number 2. It's got to be on with your facilities, not company facilities. You're not using the company laptop, right? You're not sitting in their office. You're not using their stuff. And number 3, can't be the thing that the company hired you to do. Right? Kind of makes sense, doesn't it? Now, if you do have day jobs, and if you are doing this nights and weekends, you quite certainly, I'm just going to set this right here, have signed a very tough NDA, an invention assignment with your current employer, especially if they're one of the bigger companies. And that might be very, very broad. It will have language in there that's pretty scary when you read it. It says that when you want to work for them, you assign everything you think about, while you're employed. Some of them are a little more thoughtful, and they'll say, well, we're going to carve out, stuff that's out of the course of employment. But those 3 rules I just gave you, that's California law. It's California Labor Code. California imposes that on top of every contract you might sign with your employer. So that agreement you signed is important, especially if it calls out very specific items. But those 3 rules are the things to keep in mind. And by the way, we can make this interactive if you'd like. So if anybody's got questions or comments, let me know. This is really significant, by the way, here in the Valley. I don't know how many of you have day jobs, but I see this over and over again. We're all on LinkedIn, right? Except for the people who are too cool to be on LinkedIn. We're all on LinkedIn. And like the first thing people do when they go launch their new startup is they update their LinkedIn profile. You might want to see who's checking you out. There's almost 100% chance that when you leave your old company and go start your new thing, your employer is going to go check out your LinkedIn profile. So don't do this. I see this over and over where people jump the gun on updating their LinkedIn profile, and they kind of announce that they're CEO of their new startup before they've left their employment. That's a really bad idea. That is really bad evidence there. That is bad optics, we call that. Okay? So be careful, because people are paying attention to this. And what's likely to happen if there's some suspicion of this is you're going to get a letter, especially if you're in a business that's competitive with your prior employer. You're going to get a letter from your prior employer, saying, we want to remind you that you signed a very tough invention assignment with us, and we jealously protect our intellectual property, and you better not be stealing our trade secrets, and if you are, we're going to be watching you. That happens regularly, okay? And you want to be able to respond and say, yeah, we would never dream of stealing your trade secrets. We're well aware of our obligations, and we've been very careful about how we've orchestrated this. So that's number 1. If you do mess this up, that's why I say it's a dead-on-arrival type issue, because you just can't go forward if you don't own your business, if you don't own your intellectual property, if you don't own your idea. Questions? Move on. We're going to move on. We're going to go fast. We got about an hour here today, leaving time for Q&A, right? Okay. I'm going to change the title of this, because I gave this talk yesterday, actually, about record keeping, and went on for about 10 minutes about it, and somebody raised their hand and they said, so should I keep it on a flash drive or on a computer or at my lawyer's office? So well, I don't care. That's not the issue. The issue is actually getting documents signed. So rather than poor record keeping, let's just say documentation. Things need to be documented. Now, you'll be surprised how little it actually takes in the law to establish something. I can't tell you how many people have walked into my office with cocktail napkins, just screwed everything up, because that is binding. That is good evidence. That does tell me, where you got that idea from, or it does tell me who you owe some stock to. So the important thing is having something in writing signed. If you don't have stuff in writing, it's kind of your word against theirs. Now, where this normally comes up is in splitting up equity, because that's where people do business on a handshake. And that's a really bad idea. You really need that in writing. And you certainly don't want it to go unsaid. Again, this is another dead-on-arrival issue. I have this happen frequently. where companies will, the three college buddies will get together and work on a project, just assuming they're going to be equal partners in it, and they actually get a little traction, and an investor comes along, and they have to come and document the deal and put it together, and we come to find out they don't have a meeting of the minds on the equity split. Unless they can agree, the company's done, right? No investor is going to invest in a lawsuit, not that kind of lawsuit, unless you're a super hot company. And around here, the investors are awfully spoiled. They have lots of opportunities, so they don't need to buy a problem. The last thing they want to do is give their money to the company so the company can give it to someone like me to go settle a dispute. Very simply, you should have something in writing that shows especially the equity split. The second thing that ought to be in writing, we'll talk about in a minute, is vesting. You really need to get this stuff in writing. The good thing is that if the parties are agreeable, we can fix this really easy. We can paper over stuff that happened but nobody bothered to document. We can do that after the fact. It's only when they don't agree. It's only when when you're down the road and the writing's on the wall and one of the founders realizes they're not going to be around for long, that they're going to start making demands on the company and maybe press their leverage and realize they have tremendous leverage in a scenario like that. The other reason I mention this, I want to go on to the second part of this, but this is just a common theme. Everywhere I go, I see people do business on a handshake or on ambiguous emails. But the other aspect of this, I want to mention that's less not keeping track of who has. The records are so poorly documented because it doesn't happen until it gets signed, as far as I'm concerned. I need to see a signed document, or it didn't happen. But in everybody's head, it might have happened. It might have granted stock. That sometimes we just have to kill the company and start over. I have to do that about once a year, it seems. And that's expensive. Okay, that is expensive. You're going to pay me a lot of money to have to go back and reconstruct. So let's not let that happen. And then the third component of this I want to mention. I have had a couple of clients. I had one in particular who was he was a really good guy, smart guy, and he had raised money from I think he raised about $9 million, but he had just so many investors. It was just small amounts from all of these people. And he had promised them all certain percentages. And he just didn't keep track of it. He knew who they were, but he never got around to actually issuing the securities. So in year one, when he promised somebody 5% for their investment, that made a lot of sense in year one when the company's value was X. But never got around to documenting it. So in year 5, when you remember the story about Bugsy Siegel and Sands Hotel where he sold it 2 or 3 times? This guy ended up selling his company more than once. Because the percentages, if you added them up, they would be more than 100%. So that was purely a documentation issue, because that's not what he intended to do, right? He intended to grant a certain number of shares as of that date, but they just never got around to papering it. And you might say, oh, well, that's an interesting story. I'm sure he hired you and you just fixed it all. No, we couldn't fix it. We couldn't fix it. That poor guy, he ended up in jail on securities fraud because he had all these investors come along and say, look, you sold more than 100% of your company, right? That's securities fraud, And they complained to the corporations commissioner. The corporations commissioner turned it over to local DA. And I was surprised they actually prosecuted. He didn't take the money and go to Bermuda. He didn't buy himself a new car. He put it all in the business. But he just was so messed up on his paperwork that it constituted securities fraud. You don't want to be in that position. That was purely a paperwork issue. So I might be spending too much time on this, but you need to know this is important. So the thing that most often does not get documented that really needs to be is vesting restrictions. Does everybody here know what vesting means? Does anybody here not know what vesting is? Okay. Vesting is this idea that you earn into your shares through continued employment or continued service. So for example, if I'm a founder or any other service provider and I get stock in a company and I have a 3-year vesting schedule, that means that those shares will be subject to forfeiture if I terminate my employment anytime before those 3 years are up. And usually it vests over ratably. We usually have something called a 1-year cliff, meaning that you don't vest in any shares until the end of the first year. Then you'll vest in like 1/3 if it's 3-year vesting, and then monthly or quarterly after that, you'll vest in them. And the way that mechanism works is that if I, the service provider, leave employment of the company, I get fired or whatever, the company, sometimes it's automatic, sometimes the company has to give a notice, but they will just buy back my unvested shares at cost, which for founders is going to be like really, really small, almost zero. That's a vesting restriction. Why is this so important? It's so important because if a founder leaves the company, or not even a founder, anybody who has a substantial stake, you need their shares back because you need to find someone to replace them, right? And I have seen companies many times become unfinanceable because there were too many unvested shares sitting in the hands of people who were not providing any value to the company. And that means there's just not enough common stock in that pool. When you go to the investors, the common stock is for the service providers. That's you, the founders, the entrepreneurs. The preferred stock is for the investors. There's got to be enough common to incentivize the team. Because startups, that's their currency, right? You got plenty of stock, you don't have a lot of cash, so you're going to use that stock to compensate and reward people. So you have to have enough of it. So if somebody leaves, you need their shares back so you can give it to somebody else. There's like I don't want to mention the name, but there's a pretty famous company up in San Francisco, a gig economy, a business, that had 2 founders, 50-50, 2 women. They were smart enough to actually document the share issuance. They did not impose any vesting restrictions. Almost immediately after they formed the company, one of them said, I think I'm going to move to Hawaii. I hear it's nice there, and never lifted another finger to help this company. This company is notable because it is the exception. That should have been it. It should have been just dead and over with at that time. But it was such a good company that they were able to go on and get financing and become a very substantial, significant player. But the co-founder who did all the work still grumbles about that today, like what a huge mistake that was. And as you can imagine, there's some bitterness there. I mean, you got one person doing all the work to make somebody else rich who's not doing anything. So you got to have vesting. How long should a founder vest? Anybody? Anyone want to offer up a suggestion? What do you think is 5 years? I got 5 years. What do we all think is standard?
4 is
4, and I heard 5, 4, and 3. Okay, all of those are right. My approach is for founders. I usually do a 3-year vesting schedule, sometimes 4, if 3 or 4. For optionees, I'll usually do 5, sometimes 4. And those numbers kind of range depending on the company. But the reason I do it a little quicker for founders is because we all kind of know that you're going to have to reset your vesting once the investors get involved. They're going to come in and they're going to want you to start over because they need you to stick around long enough for them to realize on their investment. So I'm more protecting the founders from each other or the company from the founders than anything else. Then the investors will come in and renegotiate that. Optionees, rank and file should be a little longer because it's harder to go back and renegotiate with those folks, right? How about advisors? You know what advisors are, right? Those are those people that your company is going to want and need to come advise on very specific matters. For example, I advise several companies as an advisor on financings. Not legal, but just the financing aspect. So they don't pay me in cash, they give me stock. And then they put a vesting restriction on it. Advisors might be market luminaries. They might get you your initial sales. They might be people that really understand your technology. Just very specific areas of expertise that your company needs. They're almost always compensated in stock or options. How should they vest? What do you think? 2 years is usually typical. And the reason why is because you need them for a very specific task, right? And they should complete that task within 2 years. If they don't, they're not an advisor. They sound more like a member of the team, don't they? Or a consultant, or something like that.
And no cliff, right?
And no cliff, that's right. And no cliff. They just monthly starting from that point. So let me pause on a couple of other things about this. Just 2 things. Number 1, with employee, now remember what I said. Vesting, your vesting ends when somebody terminates employment. Well, if your person is an employee, your service provider, it's pretty easy to know when they've terminated employment, right? They stop showing up at work, or you fire them, right? Or you stop paying them, or whatever it is. Sometimes we run into issues, and this comes out of the woodwork, could be years later, when a company finally does something, where you have a consultant, who doesn't submit, who doesn't punch a time card, and the consultant comes along and says, hey, I'm fully vested. It's been 3, 4, 5 years since you hired me. And the company says, well, God, you haven't done anything for us for all those years. They say, yeah, but I was still vesting because you never terminated, my service. Be careful about that. With consultants, you really have to take a very affirmative step of just sending them that letter and saying, okay, you're done. Because otherwise you get into a dispute. Well, are you done today, or are you done the last time you worked for me? Right? So I did some work in 2013, I didn't do anything, and then I did some work in 2015 again. The consultant's going to say, well, I was employed by you, during that interim, because that's the way consultants work. You come to me on very specific tasks. I've seen that come up. You have to be careful about it. And that's one of those issues, again. This is why it's good that you educate yourself. That would not likely come up in a conversation with your lawyer unless you raised it. So be aware of that. I'll tell you one other thing about vesting I want you to know about. And this is called double trigger. So if you're looking at this and you've got a big team of founders and you're thinking, well, gee, there's three founders, and what if 2 of them get together and gang up on me and kick me out and I didn't do anything wrong? Like I'm a star, but they don't see it for whatever reason. And they just kick me out and take all my shares away. That's not fair. So I think I should get full acceleration on termination without cause. I mean, if there's cause, if I'm not doing my job, I'm not showing up at work, or I'm drunk all day or whatever it is, okay, then you can take my shares back. But if you terminate me without cause, I should get all my shares vested. What do you think about that? We used to do that all the time. Founders will often ask for that and almost never get it anymore. They call that a single trigger. Here's another one. You're a founder, you say, well, what happens if this company exits before those 3, 4, 5 years are up, right? And Google comes and acquires us in a stock-for-stock deal. I should get full vesting, right? The stock I get in the deal should be fully vested, or whatever else the other consideration is. Because I've done my job. I brought the company to an exit. Again, you used to see that all the time. Rarely anymore. Rarely. It's not market. I'll just warn you. So now you're thinking, well, gee, how do I protect myself, from those bad things happening? And so what you can ask for, and what the VCs in this valley will give you now, if you're a founder, if you're senior enough, this is not for rank and file, is what they call double trigger, which means that you'll have a clause in your agreement that will say, if this company gets acquired and I get terminated without cause within a certain amount of time of that deal, like 6 months or a year, then I'll get accelerated vesting. Because then in that unlikely event, that means that I did my job, I got you to an exit, but my job is redundant because I'm the CFO or whatever, and Microsoft doesn't need another CFO or whatever it is. So that you can get, okay? That you don't have to feel bad asking for in your negotiation. Anything more than that, you're probably stepping a little outside of market. Okay? Questions about vesting? Okay, so I'm going to expand the tax discussion here. One of the problems in this valley, and by the way, I started out as a tax lawyer, and I still do a lot of that. And I came to Silicon Valley in 1991 and found out pretty quickly that tax lawyers in Silicon Valley just fall on their sword all the time. People do things here that make no tax sense. So it's taken me the last 20 years to kind of figure out a really good system on this. So let me tell you the tax things that you could think about. And I'm going to focus on really just 2. So one is choice of entity. Are all of you have an entity? Have you all formed an entity? What kind of entity do you have? Delaware C Corp. Everyone's got a Delaware C Corp. I sat in one of these talks one time and somebody said to the speaker, said, why should I have a Delaware C Corp? And I said, well, because that's what Google is, that's what Apple is. They ought to know, which is a really bad answer because you are not Google and Apple, not yet. Here's why you have a Delaware. Well, tell me, why do you have a Delaware C Corp?
I actually didn't
I'll tell you why. You have a Delaware.
Tax-friendly area.
What's that?
Tax-friendly area.
Well, not so much. It depends how you look at it. I'm going to get into that in a minute. The biggest reason is because that's what the VCs will invest in. They want to invest in C Corps, right? And Delaware, there's a whole other reason. We go to Delaware because that's just the gold standard. I mean, I'm a California lawyer, not a Delaware lawyer, but 99% of the companies I form are Delaware corporations or Delaware entities. You have a much friendlier corporations code. It's easy to understand. It's simple. It doesn't have all these activist provisions in it like California does. In particular, if you're interested, I'll just tell you, you can abrogate class voting in Delaware, which the VCs insist that you do, so that one founder can't hold up a sale. You can do stuff that's very business friendly in Delaware. The second reason is the Delaware Secretary of State's office is just so much easier to deal with. Oddly enough, California has come a long ways in the last few years, but it's still it's not a very friendly Secretary of State's office. Anyway, getting back to the tax side of this. So it used to be that C corporations were taxed at a rate of 35%, and this was a much tougher discussion because you would pay two levels of tax in a C corp. One at 35 at the corp level, then the individuals would pay tax again when those proceeds were distributed to them at, up to 20% up till 2 years ago. So you'd end up paying 50%, plus state. So it was for a profitable company, it was an unfriendly thing to do, or an inadvisable thing to do usually, but we still did it. The rate of tax on C corps now is down to 21%, 21 from 35. All right, so now it doesn't look nearly as bad as a tax matter. So that kind of mitigates in favor of using the C corp. But let me describe the differences here. So what could you be other than a C corporation? You could be an LLC or an S corporation. Those are pass-throughs. So with those, the entity itself doesn't pay a tax. The owners of the entity pay the tax, but only one time, right? It's like it's not there. It's a pass-through. It just passes through to them. With the C corp, corporation pays the tax, then the earnings get distributed out to their owners, theoretically. Don't see that happen often, but theoretically, then the owners pay again, right? So you're combined, a much higher rate of tax, 40 to 50%. LLC, S corp, you only have one level of tax, so it's much more tax friendly. Now, why is everybody a C corp then? Well, one reason is because the VCs will only invest in it. That's really the biggest reason. Now, it's not so bad with 21%. There's a third reason called qualified small business stock. That's a huge reason. Has anyone ever heard that clause before? It's been around for a long time. It's made it through our last 2017 Tax Reform Act. It has bipartisan support. And what it provides is that if somebody buys originally issued stock in a qualified small business, like an investor or a founder for that matter, and you hold it for 5 years, then the gain on that sale is wholly exempt from federal tax. Wholly exempt from federal tax up to the greater of $10 million or 10 times your cost. That can be big. That can be really big. I have a client that exempted has close to $100 million from tax. Think about that, $100 million of tax-free income, right? It's a huge giveaway. It's a huge giveaway. So it's important to investors. That's another big reason that you're going to be a Delaware C corporation, right? So that the investors, you can offer them that benefit. To be a qualified small business, a couple of things. Have to have less than $50 million of assets. It's a balance sheet test. Has to be a C corp, can't be an S corp or an LLC. Has to be in an active business and a non-professional service business. If you're a registered engineering business, that won't work. Accounting firms won't work, for example. And then it has to be held for 5 years. So it's a huge benefit. And we could talk for a long time about that. Now, those are all the stakes. Nevertheless, I still see companies come in and we still have this discussion because people don't do that enough in this valley. And I think we should, because not everybody is going to be a venture-backed company with investors that want qualified small business stock treatment. So the way I look at it, it's one of two ways. Most of the companies I deal with, It's what I call go big or go home companies. They're either going to be huge successes, they're going to raise money from the investment community and scale and be a very big company with never having a cent of ordinary taxable income, because they don't want taxable income. You want customers, you want users, you want to build your goodwill. That's most of the companies I deal with. That's a C Corp, right? Because if you don't execute on your plan, if you don't scale, it's not going to matter anyway. It's going to be a big loss. But if you do execute, you need a company that's going to be able to accommodate a venture capital investment and then do a merger on the end, or an IPO, or all that C corporation stuff. That's one kind of company. That's a Silicon Valley startup. On the other end of the spectrum is what I call a lifestyle business. They're never going to scale. They're just going to immediately have income. Consulting companies are like this. They're going to throw off a good annual return to the owners. People will make money on it, maybe even a lot of money. But we're never going to take VC investment. We're never going to scale. We're never going to be a unicorn. We're never going to go public. That's a pass-through. Just do the numbers tax-wise. That works out better. Problem is, a lot of people I talk to, I ask them which one they are, and they say, I don't know, I think I might be both. You know, we can make this into a profitable business, but if we attract some investment, we could scale this thing too. So what do we do with a company like that? Anybody? Well, what I like to do with it is start as a limited liability company, because it's very easy to incorporate an LLC. Limited liability company, it's a pass-through. You get the tax benefits when you're on this end of the spectrum, you know, being your lifestyle business. But if you do happen to attract investment, we'll quick incorporate it into a corporation, and then you can get the benefits of qualified small business stock and everything else on the other end. So just keep that in mind if you have not yet formed a company and if you don't know what you should be. I wouldn't pass over this as casually as most people do. Just this spring, I did the 5th or 6th deal for one of my serial entrepreneurs. I'm very old. I've been doing this a long time. And the first deal I did for this fellow was 25 years ago, and this is his 5th or 6th one. All of them successful exits. All of them like around $30 million or so, somewhere in there, 30 to 100 million. And this is his last one. Every one of them was an S corporation. Every one of them. Silicon Valley company, but every one was an S corp. You know, and he built them to sell because he knew he was never going to take venture money. He was never going to build, a $1 billion company. He was going to build a much smaller company. And I got to thinking about that, so I started playing with the numbers, and like over the years, he basically doubled his after-tax rate of return by making that S election every single time. So it's something that deserves a little bit of thought. You know, you might want to think about who you are. What does Ram Dass say? Who are you? You know, figure out who you are before you make that tax election. Okay, any questions about that? Qualified small business stock. Oh good, labor laws. In 30 years, I don't think I've ever seen a startup company that has gotten this right, that hasn't violated some California Byzantine labor law. We got meal breaks, we got coffee breaks, you know, we got work from home problems, you know, device problems. I mean, just everybody. It's really hard to comply with the labor laws in California. The best we can do is to do the best we can. The good news is that the investment community, they understand that. They know that when you're dealing with startups, you're going to have some of these issues. They factor that into their decision, you know, and they won't walk away from you around here. They will in other parts of the country, but not around here, because they just understand that's part of the baggage, you know, that you have by virtue of being unfortunate enough to be in California. Now, I want to tell you just a few things about labor laws, though. Has anybody listened to that podcast, Masters of Scale by Reid Hoffman? Has anyone heard that? It is awesome. You should all listen to that. You should go home right after I'm done talking here and listen to it or download it. He has one episode in there called Putting Out Fires. And in the episode, he talks about how startups, you know, you don't have the budget to be 100% compliant with everything I'm telling you. I know that. We all know that. You would spend, you know, hundreds of thousands of dollars, you know, putting out every single fire. That's the way startups are. Right? Reid Hoffman talks about when they were building PayPal, and they just did not have the time to worry about, all the little screw-ups over somebody getting cheated out of $7 here or whatever. You know, they were busy scaling. If they'd have fixed all the little problems, they never would have scaled. He said, some fires you just let burn. You know, that was the thing. Some problems you just let go. Rest breaks and meal breaks, I'm not going to stand here being recorded as a lawyer and tell you that, you know, let it go, but I will tell you most startups will do that. They're not going to hire an HR department to make sure they get that right. However, there's another kind of fire that is much bigger. You know, there's the small fires you let burn, but then there's the Sonoma fire. What are they calling this last one, by the way, up in I need to update my lecture here on this. So what's the latest forest fire in California? Anyway, it's a big fire. It's a Napa Valley fire. You can't ignore it. You have to address it. You have to deal with it or it'll burn down your company, right? So that's what labor laws are like. There are some labor laws that, you know, we're just going to do the best we can. There are other labor law rules that you just have to get it right. And there's one in particular I'm talking about. What do you think that is? What? AB5 is right. Independent contractor classification. So here's the tension. You're a startup, you know, you're trying to save money. You don't want to hire employees because then you got to pay workers' comp, and you got to withhold, and you got to pay payroll taxes. So you hire independent contractors, right? So two things with that. One is tax, one is labor law. And so that is the big mistake. If you misclassify your employees, if you treat them as contractors when they really are employees, that can be a huge liability. So here's the labor law problem. California law is class action lawsuits. So if you've misclassified a whole bunch of people, but they're all really good guys, and they're not going to, you know, they're not going to run to the labor commissioner on you. Just takes one. One person can sue the company on behalf of the entire class. So it becomes from that person's like little, you know, she's got a small liability, becomes that person's small liability a huge liability for the company. That has brought down many a company. It's brought down many a company in this state, okay? Because it is a big liability. And what are they suing for? You didn't give me my meal breaks. You didn't give me my rest breaks. Mostly, you didn't pay me my overtime because I was working weekends and nights on your project. And I'm the only one who knows that because you didn't make me punch a time card. And I get waiting time penalties because you have to pay me for every day you didn't pay me my salary, you got to pay me another day's pay. It adds up. And you get attorney's fees and statutory damages. It's a big number, right? I've seen it bring down a lot of companies, and it's brought down some. There's about 3-4 years ago, there was a big company in San Francisco, raised $10 million of venture capital. It was a gig economy business. They had one class action lawsuit by one of their gig employees. Done. That's it. They closed the doors. They did not even get through defending that lawsuit before they ran out of money. And nobody would invest in them once they had that suit pending. So classification issues are really important. You got to get that right. Now, that's one. That's the employment side. That's the labor law side. There's also a tax side. The tax side is that if you do misclassify, you're supposed to be paying payroll taxes, right? And then on the state level, there's state taxes plus workers' comp. Those numbers add up. And what the IRS does, and the EDD, the Employment Development Department, what they do when they find out that somebody has not been withholding payroll taxes, or paying payroll taxes rather, or withholding income taxes, is they're not going to go back to the employee who's misclassified and collect it from them. Oh, no, 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 no. It's much easier to go back to the company who was supposed to have withheld and should have paid. So it becomes a big problem on the tax side as well. Now, before I move on to AV5, I will tell you that the IRS and the Franchise Tax Board and the EDD and even the Department of Labor are probably not your biggest problems for non-compliance in this area. Your biggest problem is the fact that you're going to have a later investor or acquirer who's going to hold you to the fire on this. And they're going to look at this for sure, 100% for sure. You know, you can play audit lottery and say, well, gee, I got a 5% chance of being audited. I'll take that chance. You have a 100% chance of being audited by your next investor who's going to do due diligence and find this problem and ding you on valuation because of it, or create a big holdback, escrow, or just go pay the penalties and take it out of what you would have gotten in the sale of your company. So that's why it's such a big issue, more than anything. Now, AB5. A couple years ago, the California Supreme Court, in one of the worst decisions ever to be decided ever in any country, came down with a rule in a case involving a company called Dynamics. And what they did is they changed the way that you classify contractors as employees. And they adopted what we now call the ABC test. It's only 1 or 2 states that does this. And under this ABC test, if this putative contractor that you've hired, if what they're doing is in the course of your business, they're automatically an employee for wage and hour purposes. So let me give you an example. Let's say I'm well, I'll give you the perfect example. It's our gig economy businesses. Let's suppose I have a platform. And my platform, people log on and I'll connect consumers with the service providers, right? So as far as this test is concerned, this case is concerned, I'm in the business of providing that service. So even though the service provider, might not otherwise be an employee because they have, they do this for lots of different companies and they have their own facilities and there's no direction and control, under this ABC test, they're automatically an employee now for wage and hour. All right? This is what you've been reading about in the papers because this year, to add insult to injury, our California legislature took up this terrible decision that was going to kill our gig economy and decided to fix it. Well, they didn't fix it. They made it worse. They codified it. So now it's in the statute. There's some exceptions for lawyers in particular, so I was glad to see that. There's some other exceptions, but for the most part it's codified and it goes right after gig economy businesses, right? There's going to be a referendum. People will vote on it. It's like asking people to vote on whether they want to kill California's economy or not, if you ask me. So hopefully it'll go away, but it might not because of where we are. So just be aware that we've got this law, AB5 they call it, and if the person you're hiring as a contractor, if the service they're performing for you is your core business, then they're probably your employee for wage and hour. On the tax side, that is not the tax rule. So at least it's only wage and hour problems you have, not all this tax problems. And I've been in touch with the EDD a couple of times, and they know that that is only a labor law rule. They're not going to classify your people as employees under this rule. They're going back to the old test, direction and control. So at least it's not that bad. But we all think that's going to change. We think eventually it'll come down to one standard. Because think how confusing it is to have someone who's an employee for one purpose, but a contractor for another. Wow, we're running out of time. I'm going to move quickly. Yes?
Two questions on that. One is jurisdiction.
Uh-huh.
So incorporated or based or
Okay.
distributed.
Mm-hmm.
And related to this, you talked about the contractors as, for example, the example you gave is connecting contractors.
Yeah.
What about using contractors for product development, marketing, stuff like that?
Yeah, good question. So number one, this applies to where the service provider is providing the services. So that's why I say it's going to kill the economy because I have...
There's no service, just development.
Yeah, because I've had companies come to me and they say, well, let's see, if I use this California person here, I've got all these wage and hour issues. But if I use that Nevada person, I don't have that problem. Is that what you're telling me? I say, yeah, that's what I'm telling you. I say, oh, I know who I'm going to hire. I mean, I've had that happen over and over. So yeah, it depends where they are. Secondly, the other issue, well, what if you're hiring developers? What if you're hiring marketing people? Well, it depends. This is very fact-based. Is your business in the marketing business? If they're is your business doing development? I mean, if that is your core business, then you're going to be caught by AB5. For tax purposes, though, you're just going to go back to the old standard direction and control test. These are all very fact-intensive sort of analyses, but you get the idea. I had this come up today. Somebody said, well, gee, I want to hire a marketing person. Is that marketing person going to be my employee? And I said, well, what's your business do? And I said, well, we do SaaS, we just sell software. I said, well, that's not AB5 because you're not in the business of marketing. We got to go back and apply the other test now and just determine whether they're under your direction and control. Okay, I want to move on to IP because we're running out of time. This is another humongous problem that we need to worry about. Most of my clients are technology companies. Intellectual property is really important to them. And everybody knows about patents. You know, you make a registration and then you got these rights and then you can keep other people from using your patent. But patent might not be your most important piece of intellectual property. Usually it's not. There's not the only important piece. Let me put it that way. Most of my clients also have trade secrets, and they rely heavily on it. Most of your software code is going to be trade secret. What's a trade secret? 3 things. It's valuable information. Think of that software code or that customer list or that market, that know-how, that process that you figured out. Number 2, it is secret. It's not widely known and can't be reverse engineered by somebody reasonably skilled in the art. And number 3, this is the big one, you, the company, have done something. You've taken reasonable steps to keep that secret. And that's where companies make a mistake. So I want you to think about how valuable trade secret is to your company. The know-how, the process, you know, what you know about your customers, what you know about their specifications. How valuable is all that stuff to your company? If it's valuable, then you want to get that number 3 prong. You want to make sure you get it. So what's the first thing you can do to take a reasonable step to protect the confidentiality of your trade secret? NDA. NDA is number 1. You should have NDAs as much as possible of everybody who sees any part of what you're doing. That's just basic. If you don't have an NDA, you're going to have a tough time arguing in a court that what you have is your trade secret because you didn't even try to protect it. Beyond that, you should have really good security protocols in place. Be nice if you never showed any one person everything they need to know. Coca-Cola, lock it in a safe, you know, stuff like that. Just keep in mind that you need to accept, you know, you need to adopt those principles. By the way, what do you think is better, a patent or a trade secret? Because I hear this all the time. People say, well, gee, if I file a patent, you know, that's out there. Everyone's going to see how I do it. I'm going to register it. I'm going to disclose, because a patent really is a trade secret that gets registered, right? But I get protection, right? Even so, they can't reverse engineer it on me. On the other hand, my trade secret, I'm going to keep that secret. What do you think is better? Well, it depends. So I mentioned Coca-Cola, the most famous trade secret in the world. What do you think would happen if Coca-Cola had patented it?
They open the formula.
That's right. There would be no Coca-Cola. There'd be a million Coca-Cola companies out there because the patent would have expired. So for them, they said, we're not going to patent this. We're just going to keep it secret forever. You know, and if it ever becomes not secret, there probably won't be a Coca-Cola company anymore. So it kind of depends on your company. The other thing is that sometimes people don't like to patent it because someone's going to infringe. And like, we're just a little startup. We can't afford, you know, patent litigation lawyers. You know, we're going to keep this secret, you know, as long as we can. So, you know, it goes into your IP strategy, but give that a little thought. Yes, sir.
Just want to know, like, how would you protect yourself internationally?
With patents?
Patents.
Yeah, patents. I mean, we have treaties with, you know, with most industrialized nations, and you file in one country. But patents are geographic; they're local, so you have to file in every country. But you get priority back to the first filing that you did in one of the treaty countries. But yeah, good point. If you want to protect your patent in China, you better have a Chinese patent. As much good as it'll do you. Trademarks. This is another type of IP I want to call out. Yes.
Last question though, like in countries like India, for example, you want to file a patent, it's going to take you 7 years or something, and then the technology probably will have moved forward.
Yeah, I know.
Does it even make sense?
It's a consideration. I mean, I know exactly what you mean. I've got one I've been waiting more than 10 years on. You know, so that's a, you know, and I don't have an answer for that one. But it's not going to be public, at least for that amount of time. So you've got trade secret protection in the meantime. So trademark I want to call out specifically because people don't treat this seriously enough. I want you to think about where your company is going to end up and how you're going to exit, right? You're going to sell it at some point. What are you going to be selling? You're probably not going to have a lot of plant and equipment, right? Probably no land. You know, you'll have some people, and the team will be important, workforce in place. But for the most part, what you're selling in this valley, what you're often selling is going to be that user database, that expectation that people are going to come back to the company and continue to use their service. Think of Snapchat, right? $1,000 a viewer, a user is what the valuation was at one time. Well, what is it that solidifies that? What cements that? What brings them back to your product or your website? It's your mark and your logo. And that's a goodwill asset that you've built up, and it is very much tied to logos and marks. So it's really important to protect that logo and mark. So what you should do before you start building a lot of value around it is, number one, do a Google search. Okay, make sure no one's using your name and mark to the extent you can in your business. And then number two, once you know you're going to hang on to it, what they call a knockout search with the Patent and Trademark Office to make sure that nobody else is using it. And then you should get a federal registration. You should just secure it. That gives you, becomes incontestable after a time, so people can't challenge it later. Because what you don't want to have happen, and I see this happen frequently, is you don't want to get to that exit after 10 years or however long you've been building your business, finally get a sale in place, announce the sale, and then start getting letters from lawyers, please stop letters, saying you've been infringing on our trademark all this time, either pay us or stop using it. Well, you can't stop using it. It's so tied to your product. Your whole company, your goodwill would go away. So you end up having to pay. Yeah, don't let that happen to you. Yes, sir.
If someone owns a patent but is no longer in business, or sorry, not patent, a trademark, and is no longer in business, is that trademark still valid for the person that owns it, the company that owns it?
Yes, as long as it was validly granted trademark, yeah, they have rights. There's no requirement that they, that they continue to practice it.
Or continue to use it if they just don't?
I don't think so. I have run across that, and people are concerned enough about it that we paid the trademark owner. I don't know if there's an argument that it lapses as some. I don't know. I'll have to check on that. I don't think so. I don't think it matters. I think it's still a valid trademark. Because you think about companies liquidating and dissolving all the time, where they go out of business and they transfer the trademarks to somebody else because they're valuable assets, even though the company's not using it. So I would want to double check with my trademark people, but I'm pretty sure it still has value. 409A, does everybody know what that is? That's the tax rule that most commonly we understand means that options get granted at fair market value. We all know about that. I'm not going to spend a lot of time on that. Where it comes up as a mistake is when companies start to accrue salary. Because you're founders, you've been working for nothing, so unfair, you should get paid, right? So we're just going to put that on the balance sheet as a liability. And then when you do your financing, the idea is you'll pay all of that deferred compensation. So number one, your investor probably won't let you get away with that, just so you know. But even if they do, or even if they don't, the tax rules treat that as deferred compensation. And when you have deferred compensation, that's where you earn money in one year, but you don't get paid until a later year. You have to comply with a very specific and extensive regulatory regime under Code Section 409A. And it's a rare startup that will actually comply with that. Okay? It means that you have to have a written plan, you have to have a time or event certain of distribution. So yes, theoretically you can do this. In practice, it requires you jump through quite a few hoops. So there's ways to do this. There's other ways to accomplish the same thing. What I'm alerting you to is be careful about it. In other words, you could have the amount paid by March 15th of the following year. That's fine. You could have it paid on a very specific date at a specific time. That's fine. But to just leave it out there open on your balance sheet accruing every year, that's not. That's going to result in tax and penalties to you, the person accruing the deferred comp, and a payroll tax obligation on behalf of the company. Failure to comply with securities laws. I mention this because it is so easy now to go break the law. Right? Anybody in here can go online and download a safe or a convertible note or even a Series Seed stock term sheet or documents online and fill in the blanks and take money from somebody without complying with securities laws. It's a really dangerous thing to do. Number one, federal and state filings are oftentimes required, depending what state and how much. Number two, there's a sophistication requirement and oftentimes an accredited investor requirement for the investors. Number three, there are disclosure requirements under the federal law. You really should not do this without a lawyer. Do not sell stock without a lawyer. In my career, I've seen 2 startup founders go to jail, prison in fact, over doing this, just getting this wrong. You know, securities fraud is very serious. And the problem is it's so easy for people to just do this on their own. The good news is it's really rare anybody gets criminally prosecuted. What's more likely to happen is the company doesn't do well and the investor comes back and says, you didn't comply with the law, give me my money back, right? And it was willful, so you personally are responsible. That's the more likely result. We can fix all that, by the way, if you've done that, but you're better off not making that mistake in the first place. And finally, I want to make sure you choose the right lawyer. And I tell people that you're fortunate here in Silicon Valley, there are a lot of startup company lawyers, right? So you don't have to go far. The further you get out of this valley, though, the less likely you're going to find, or the more likely you will find somebody who doesn't do this every day, all day. You don't want a lawyer who's too expensive, doing big deals out in New York City that's going to charge you $100,000 to incorporate you, which I have seen, by the way. It's no joke. You also don't want your brother-in-law who's the assistant DA, because how tough can it be anyway, right? Make sure you find a startup company lawyer so that you can ask all the questions about all the things that I've just told you and you'll get all the right answers. Okay, any questions? How are we doing on time? We're a little over an hour, aren't we?
We're a little over. But yeah, if you have any time to hang out, I'm sure some people want to stick around. But
All right.
otherwise, thank you so much.
Oh, thank you. Thank you all for being here.